So as we discussed yesterday, the use of AI systems in healthcare needs data. We need to capture data, to reuse data, and obviously that raise many issues regarding privacy, consent, ethical research, ethics in research. And also, like with all the new IoT tools, the connected self, biohacking, there is like more and more issue regarding security and privacy. And so during this session this morning, we will try to present an overview of current privacy issues raised by AI, notably in the healthcare system, and to discuss like possible legislative changes. And so joining me for this conversation this morning is Canada's leading privacy and information law expert, Dr. Teresa Scassa, who is a full professor here within the Faculty of Law Common Law section and the Canada Research Chair in Information Law and Policy at the Centre for Law, Technology and Society. And as it was announced yesterday, a member of the Government of Canada new Advisory Council on AI, so she's gonna solve everything for us, obviously, with my dear colleague Ian Kerr. And so we are in Canada, but development of technologies often happen on a global scale today, and lately all over the world people have been afraid by four little letters, GDPR. So to demystify the new EU set of regulations regarding privacy, so GDPR, cybersecurity and e-health, I'm delighted to have with us this morning our colleague, Dr. Céline Castets-Renard. She's a professor in the Université de Toulouse in France. She's also a visiting scholar at Fordham Law School right now, and very new exciting affiliation will soon be announced. And so this session is designed more as a conversation rather than just like academic legal presentation, because it's Saturday morning after all, and we all need more coffee. So I have a series of questions for our speakers, and then we will open the floor to you to discuss your concerns with you, although obviously would not be like free legal consultation on the latest issues in your own labs. And so, yeah, as you have noticed, we are video recording everything, including the questions, and we will put everything online on the center's websites afterward, also with the slides, just because I know some people have been asking. Of course, if you don't want to be recorded, like consent, privacy and stuff, please let us know. We will take notes. But so to go back to privacy in AI and health, as we said yesterday, like from research on cancer to mental health, data is needed to develop and train better systems. And more personal health information, sensible information are being collected in the private sector with apps, DNA tests, as it was mentioned with the previous panel, and so on. And so first, I will like to have Teresa's take on it, and like, does the Canada's privacy legal framework currently adequately address the protection for personal health information?
Oh, thank you. So that sounded like opt-out consent for video recording. Just thought I'd note that. Thank you very much to the organizers for the invitation to participate on this panel, and thank you to all of you for turning out on a Saturday morning for the conference. In terms of the question of whether Canada's privacy legal framework adequately addresses the protection of personal health information, the broader question that I like to ask is whether Canada's personal information protection regime adequately protects any personal information.
No.
Okay. Yeah, and the answer to that is no. I thought I'd start, and I think this is going to be an interesting contrast with the discussion of the GDPR. One of the things about data protection law in Canada, and in the first panel, Nathan Cortez talked about siloing of regulatory approaches, and I think we see a tremendous amount of siloing in the context of data protection in Canada, and it's siloing across jurisdictions, but I think more and more it's also siloing across issues relating to data, so that and we can talk a little bit more about that later, but I think that's also a change or a shift that you see in the GDPR. But basically in Canada, personal health information is mostly governed by provincial and territorial laws relating to personal health information in the public healthcare sector context, with a few other contexts added in that may have private sector dimensions, care facilities, pharmacies, and so on. And so for the most part, it's built around this concept of how healthcare is delivered in Canada, primarily through healthcare custodians in a public health system. And then we have what's taking place in the private sector, which is governed by for the most part, but not exclusively, by the Personal Information Protection and Electronic Documents Act, lovingly known as PIPEDA. And so, and that legislation governs the collection, use, and disclosure of personal information in the course of commercial activity. So it's really a private sector law. And increasingly what we're seeing, and there was some talk about some of these apps and so on, but we're increasingly seeing a variety of different apps that are either collecting personal information that may be used in health-related contexts, and that could be Fitbit or 23andMe, Ancestry.com, even Facebook or Twitter, that are collecting this information that may be used in a variety of different applications. And we're also seeing more health-oriented applications directly at consumers. So the private sector context is becoming increasingly important. And so we have this kind of regime which is different across jurisdictions, although at the provincial level, there's a lot of similarities between the laws, but it's kind of jurisdictionally organized, and then it's organized across private and public sectors. And I think this is one of the challenges is how to deal with data protection in the context of the big data society generally, whether it's health or any other sector, where these divisions or lines don't necessarily make a lot of sense in terms of the scope of the technologies and the scope of data collection and use and application. So I'll just stop there because I think Céline will have something to offer us on the GDPR.
Yeah, exactly. So in Canada, it's a patchwork. Some people would say it's a mess with the set of regulations. And so lately, the EU tried to reform everything with the GDPR, a single set of regulation, and also there is the directive and stuff. So could you try to present us a quick overview of this very complex piece of legislation?
Thank you. Is it good?
Yeah.
I have to be patient.
No, that's okay.
No? Okay. Thank you for having me. Thank you, Florian and Colin. Merci beaucoup. It's a pleasure to be here. And I have a heavy task today to present the GDPR because it's around 99 articles, more 100 pages, so it's a lot. But I just want to highlight 2 or 3 points for this overview. I would like to focus on subject matter, territorial scope, and material scope, and to link this question with the Canadian regulation. Firstly, I have to mention the GDPR was enacted in 2016 and entered into force in 2018. And this new regulation, the General Data Protection Regulation, GDPR, repealed a previous directive which was enacted in 1995, so it's not new. We already had a legislation, a data protection regulation in Europe. And this question is very important in Europe because we consider data protection as a fundamental right, and it's inside our EU Charter of Fundamental Rights, Article 8, and it's a number different of privacy, which is Article 7. So it's two different questions from a European perspective. And when we focus on data protection, the first thing I should say is we don't consider if the data controller or data processor is a private or public actor. It doesn't matter. We consider only natural person and personal data related to this natural person. And no matter what kind of data controller we could have, so we don't have this kind of issue from a European perspective. And when we talk about data protection and personal data, we have a very broad definition because it's any information related to a person, natural person, which permit to identify or permit to be identifiable directly or indirectly. So it's a very huge definition, and the problem here, I should say, is in a big data and AI system. Usually we could have an identification if we cross several data. I think that's a weakness of this regulation because it's very, very broad. And I should also add that inside personal data, we have a specific category which is sensitive data. It's a list of data such as political opinion, religion, or sexual orientation, health. And we have two new categories of sensitive data, which two new types of sensitive data, which are genetic data and biometric data, and previously we already had health data. So there is no doubt here, all this kind of data are sensitive data, and it means we have a stronger regime of protection, stronger than personal data in general. So in this field of health, we have to pay attention to this sensitive data and to the health data. I should also add another thing. Maybe we could talk about the territorial scope later, but because the GDPR applies inside the EU, but outside as well if the if the data subjects are in the EU. So there is an extraterritorial effect. I know we have many trouble with other countries because of that. I can understand. And I should add something interesting. Inside the EU, we have some question of jurisdiction between EU and member states, and health and social care are in the jurisdiction of the member states, and it's not a policy from the EU, but the EU can promote and encourage the cooperation between the member states, and can also fund and stimulate innovation. And in this area of AI and big data, there is a question of scalability and a question of money, of course, to perform this field. And it means more and more EU have a role to play in this game.
Yeah, thank you. And so, as you just said, one of the issues, or like depending on the perspective of GDPR, is that extraterritorial effect of GDPR. And like right now, for example, in Canada, in the tech sector, I know that most of the companies are more afraid by GDPR than by Canadian privacy framework, because it's toothless. Like there is no sanction, there is nothing. And in GDPR, it's important because if you go wrong, they're gonna come for you with like huge sanctions up to like 4% of your global turnout. So that matters for any kind of companies. And so from a North American, from a Canadian perspective, Teresa, what do you think of that European like global approach? And we know that there might be upcoming reforms in Canada, just announced like last week by the federal government. So what do you think of this, and what could be the future of privacy law in Canada on that side?
Yeah, well, one of the things that I mentioned siloing before, and then talked about jurisdiction and sort of having all of these different laws and dividing the field both in terms of sort of federal, provincial jurisdiction, but also in terms of public and private sector, and how some of that presents structural challenges to dealing with data protection in this context. The other type of siloing that we see taking place around data is that, and the GDPR addresses this to some extent, is that there are a real bundle of issues relating to how personal information is used and the implications of those use. So in Canada, for example, issues of discrimination are largely dealt with by human rights tribunals, and we have those siloed at federal and provincial levels, and issues of excessive concentration of data are dealt with by the Competition Bureau, and issues of and some issues relating to data and how it's used and the consequences of its use will be dealt with by consumer protection agencies, which are mostly at the provincial level. And so we tend to have this siloing of issues relating to data that makes it really complicated in terms of thinking about what kind of, when you have a problem that's related to how personal information has been used or applied in particular contexts, it makes it complicated to even think about whether this is a privacy issue or a human rights issue, and how do you address that. And so one of the interesting things about the GDPR is that you see a lot of those issues start to come into the GDPR. And so the concept of data portability relates to an individual's control over their data, which is a concept tied to privacy or personal data protection, but it's also linked to consumer protection. It's also linked to competition law. The right to an explanation in terms of how your data is being used is certainly tied to how your data is being used in the context of algorithms is very much linked to the AI context. And so you start to see more of these issues being rolled into the GDPR, or at least concentrated a little bit more within the GDPR. So one of the things that's interesting, the proposals for reform that Florian was referring to are really for reform of the private sector, the federal private sector law, which would certainly apply in the context of most private sector healthcare apps, for example, or health-related apps. The ones and services that come from the private sector. It doesn't address the public sector, but what the federal government has announced this week in relation to its proposals for PIPEDA is to maybe start looking at some of these issues that kind of cross these silos around portability and right to an explanation and so on, and start to think about addressing them in the context of that particular law. And I think that may be a more helpful and more useful approach to regulating some of the issues that we're seeing around AI and big data. But again, that'll be private sector course of commercial activity issues, mostly across Canada, unless they are in Alberta or concentrated in Alberta or BC or Quebec, which have their own legislation, unless they're in a crossing border. Anyway, this is the kind of stuff that that you want to roll your eyes at, but at the same time, you know that lawyers are thinking, this is what we get paid for, so don't make it too simple. Anyway.
Yeah, so that's perfect for me to continue on this. So, and this is the conversation we had at the previous panel, is regulation a blockage to innovation, or can it support it? In my opinion, privacy, I know often privacy and lawyers are still at the people blocking everyone, and I sit on a research ethics board for the Ottawa for health sciences, and so I know the opinion that the researchers have of myself on that board. But still, I think it's important, and privacy can actually be a tool for innovation, but for startups and engineers to respect privacy, we need to have frameworks that people can understand. Because we need data, personal data, sensitive data. And for a long time, people have been oh yeah, but we can just de-identify the information, and so that's okay. And it's often still presented as a solution for any kind of research and development, although today we more and more hear experts stating that in the big data age, like de-identification that doesn't work anymore. It's pretty easy to like re-identify information. And 2 years ago, we had Latanya Sweeney from Harvard who came to the Ottawa to present like her work, and she could like super easily re-identify data set coming from anonymous health data. So is it true? And if so, what application does it have for data sharing for research purposes? How professionals can deal with it, and how can we like protect patients? Like, what is the EU take on that issue of de-identification?
We don't talk about de-identification, but anonymization, but I guess it's the same. I should say when we consider anonymous data, in this case, this kind of data are outside the scope of the GDPR. That is very clear in the recital of the GDPR, which are not binding, but which are helping and help for understanding the GDPR. So if the data are anonymous, it's no more personal data. But I should also say there is a kind of precaution concerning this anonymous data, because as you said, very often we can re-identify later. We don't know when, we don't know why, we don't know for what, but very often it's it could be re-identified. So in the GDPR, except this question of out of the scope of the GDPR, we focus more on the notion of pseudonymization, which is not not a tool to avoid the GDPR, because if your data are pseudonymized, it's still personal data, and you're still inside the scope of the GDPR, but it's a tool, a way to safeguard the data, because there is an obligation of security inside the data, and it's a way to protect your data sets, and if you should report a breach notification, it could be very helpful to say, oh, my data are pseudonymized, so maybe the harmful would be less if it's not the case. So it's only a way to protect the data and not to avoid the GDPR.
And Teresa, what about Canada?
So there are a number of interesting issues around de-identified information, personal information in Canada. I'll start with one which I think is really interesting. It's the question of whether it's in or out. And Céline just mentioned in the GDPR, if it's de-identified data, it's not covered. That's an interesting question in Canada. I don't know if you remember. It might have been last year. It could have been 10 years ago. Time is such a blur to me these days. But I think it was reasonably recently. There was a kerfuffle in the news about information kiosks in malls, signs in malls that had facial recognition technology in them, and that any time you looked at a store directory in one of the malls that had this technology, it was scanning your face. And people were outraged by this, and the mall's response was, we're only trying to collect metrics on approximate age and gender. We're not interested in recording the images. We're not actually recording the images. We're not collecting personal information. Therefore, it's not captured by PIPEDA or the provincial law that would have been applicable, I think, in Alberta. And that's an interesting question. If you know, is this de-identified information collected at source personal information, or because it's de-identified right at that point, is it outside the regulation of the legislation? This is an issue that's come up in the context of the sidewalk Toronto development as well. So that's a question that remains to be determined whether it's in or out. And I'll come back to that in a minute. In terms of healthcare, perfection is not the standard for de-identification. I see in the room Khaled El-Imam, who has done a lot of work on de-identification of health information so that health data can be used for research purposes. And the standard has never been perfection under the provincial personal health legislation. And it's really de-identification that's seen in a particular context. And so it's evaluated in part in terms of risk of re-identification, but that's not just a formula of sort of like, can we, if we throw all our resources and efforts at this, can we bust it? But it's more a question of, is anybody going to bother? Is anybody going to invest these resources into doing it? Is it sufficiently protected in this context from re-identification? Now, admittedly, that still is difficult in the context of AI, where you don't know what information might be useful for what purposes and what people are doing with it, and it does become easier and easier. There are more data sets and there's more algorithmic power, and so re-identification may be more tempting in other contexts, and it does become a little bit harder. But the standard has never been protection, the standard has never been perfection. With the view to the fact that you have to at some point be able to use the data, and if it's going to be perfection, then you're not going to be able to use it. And what we've seen emerging in Canada more and more are explorations of data governance solutions, so that you can have data trusts have been suggested in the context of Toronto, but there's lots of other examples, including in the healthcare context, or where you have research ethics boards that look at who wants to use the data and for what purposes, and that use licensing agreements to impose restrictions on what the researchers can do with the data, whether they can further share it or not. Often the restrictions are, you're not to re-identify, not to attempt to re-identify. So there are data governance solutions that are coming up both in public and private sector contexts to try and address the use of de-identified data. Another thing about de-identified data, of course, is that if in some cases de-identified data will be less useful than identified data, or if the de-identification process is too rigorous, you lose too much detail and it's not as useful for certain purposes. And again, data governance can be a solution to that problem by providing for data, for the sharing of data under tightly controlled circumstances where there might be more risk of re-identification, but where you're going to control it more. So there are ways to manage that as well. And the one other point I want to make about de-identified data, and this has come up in the private sector context as well, and perhaps in particular, is that this whole issue of whether de-identified data is in or out of the data protection regime in part goes back to these silos where we think of data protection laws as dealing with privacy and personal information, and therefore if you de-identify it and it's not personal information, you don't have it, it's outside of the regime. But we're recognizing more and more that there are all kinds of harms that can flow from the use of even de-identified data. There can be problems of bias, for example, in data sets, or the use of data that leads to harm through bias. There are issues of ethical uses. There are a range of other uses related to data that are important whether or not there's been de-identification. And so that's one of the reasons why we're also thinking about reform of data protection laws that might think not just in terms of is it personal information or not, but how do we deal with the issues around data use, whether it's personal information or de-identified information.
Yeah. Yeah, indeed, like for researchers, the issue around like data management and tracking consent and use and reuse of data, it's one of the main issues right now. Like there is many solutions, technical, legal, being proposed. As of today, we always have a blockchain solution. There are obviously people proposing to use blockchain to deal with that. But at the same time, and from a RIBI perspective, and like when you do research, we don't want to have like personal information within the data set. At the same time, if you want to control consent, you need to have that information somewhere to be able to control the consent. So now it's very complex to researchers to be able like to link that information without linking that information. And so we need data, and right now, like I would like to hear both of you on maybe like possible solutions that are like emerging regarding data sharing for AI, for training AI systems. Maybe the need So either like any barriers, do we need legislative change? Also to keep in mind that, often we see like the bad side of this, like kind of apps and solution just collecting data with or without consent. At the same time, we also have people who want to give the data to help health research, to help to improve systems. And I think it's Colin, yesterday we discussed that, or to like think maybe of those people giving the data in the same way that some people give blood or like some body parts to help research. So yeah, I would like to hear you from the EU perspective, and then of course Teresa from the Canadian perspective.
As a solution, I have obstacles. I have some obstacles, but maybe also some solution. Maybe we should distinguish between big data without purpose, just to collect many data and not to know what to do with that when it's collected, and that should, on the one hand, and on the other hand, we also have big data and AI with a purpose and with precise kind of data. And I think that's two different ways of thinking about this question. If we consider big data in a global sense and just the way and the goal to collect data without knowing for what, but just in case it could be useful later, this kind of big data is not compliant with the GDPR, to be clear, because we have many main principles such as purpose limitation, data minimization, and it means we should know why we collect data. So we need a purpose, and one or two. It could be several purposes, but we should know what purposes we have. And there is also a data minimization principle, meaning we just collect the data we need related to this purpose and not all the data we can. So it's very important to have this framework in mind, because I think that's the spirit of this regulation, and it was already enacted in the directive. So it's not new, and we also need to have a lawfulness of processing, and it means we need, for instance, a consent or a contract or several way to have this lawfulness to satisfy, to fulfill this requirement of lawfulness of processing. So if we don't consider this kind of big data or AI, if we consider, for instance, AI and big data for a medical purpose and with a data set very precise, we can find some solution inside the GDPR, and some solution with the question of personal data donation. It's not prohibited in the GDPR because, as I just mentioned, we could find several ways to encourage and to permit this personal data donation. For instance, if we have the consent of the data subject, but the consent should be freely given, specific, informed, and unambiguous. If we want to perform a contract, if we have a legal obligation, we could find a legal obligation. It could be a policy, a goal from a global policy on this question. If there is a vital interest for the data subject or another natural person, so it could be broad. And we also have the public interest and the legitimate interest of the data controller. So we have many ways to imagine a framework for personal data donation inside the GDPR. So we could find some solution inside, but the condition is to be compliant to the GDPR. But we could find some ways.
Yeah, I'm going to talk maybe a little bit about consent in terms of as an access point to personal data. I've already mentioned data governance solutions, and I'm happy to talk more about those in questions if anybody's interested. But consent is a really thorny issue. Our data protection regimes, whether they're public or private sector, are consent-based. Well, maybe a little bit less on the public sector side, but in any event, in the healthcare context, consent-based, and PIPEDA is certainly a consent-based system. And so consent is this really central concept, but consent is becoming more and more challenging, particularly in contexts where, for example, for AI purposes, you need massive amounts of data. You may need not just data going forward, but you may need historical data as well. And at the time that the data was collected, there was no conception of this type of technology or this particular type of use, and it's complicated to go back in time and seek that consent. There are, the legislative framework, especially through hospital research ethics boards, does have workarounds where it's not practical to get consent and so on. But consent is still the gold standard that you would ask patients for consent. So consent is challenging, and of course, if you look at it in the private sector context where you get massive amounts of data that are being collected through apps, and I've mentioned a few of them, like Fitbit or 23andMe, Ancestry.com, or apps or services. There are many others. I've mentioned social media data as well that is being mined and used in a variety of contexts. Then consent is, I don't even know how to think about consent in those contexts. In most cases, you're dealing with really long, complex privacy policies, contracts of adhesion. People are not necessarily even looking at the policies, but if they did, they wouldn't necessarily even be able to understand the scope or the implications of any consent that they gave to the use of their personal information. So on that side, you get this, very, very broad, almost out of control collection of personal information that may be used in a variety of different health-related contexts. And so consent is complex in that context as well for other reasons. And again, in terms of reform of legislation, there's some talk about legitimate purposes and trying to balance the need for data with the protection of the individuals. There are some proposed solutions about, and I think you hear a lot about these both in the healthcare context and outside of it, about giving individuals more control over their personal data so that they have some kind of conceptual basket of personal information, and they can decide who has access to it and for what purposes. The risk of that with AI, and particularly I think in the healthcare context, is that you can introduce a lot of bias into your data if you're depending on people to self-select in terms of who's going to share data. And so that can be really problematic in terms of the data quality. If you need sort of a broad swath of data, then relying on people who are engaged enough with the concept of health research and giving back to the public, and for your data, and everybody else just being too busy or occupied with other things or not aware of what it all involves or what it might mean, not giving you your data, you're going to have fairly biased data sets. So it does get really complicated in that context. So I think consent is one of those things that we really do struggle with on the private sector side, just like out of control hoovering up of data, frankly, with a gloss of consent put on it. And in the healthcare context, the consent issues are a little bit different, but they are complex when it comes to AI.
Perfect. Thank you. Do we have some questions, maybe, from the audience? Because I see that the time is running, so... And we don't have a few, we have many questions. So please, sir. And if you could introduce yourself before asking the question, that would be very helpful. Then, thank you.
I've been working on the de-identification issue for 15 years. So I just wanted to give you a perspective based on that. The first thing is that there are a lot of good methods and methodologies for managing the risk of re-identification. I think our challenge is the adoption of those methods. A lot of the good practices, you have methodologies published by the Institute of Medicine or the National Academy of Medicine, the Council of Canadian Academies, the Ontario Privacy Commissioner, various regulators around the world for de-identification that work reasonably well. So it's really an adoption problem rather than the existence of good methods. And here in Canada, recently, there's a Canadian Anonymization Network, which is an entity that has been created to help increase the adoption of de-identification practices in Canada, has been set up. So hopefully that will start having an impact on the adoption issue. The second point around the attacks, so there have been re-identification attacks that were successful, but most of these attacks were done on pseudonymous data. And commissioned re-identification attacks on properly de-identified data, so de-identified data using known standards, have generally been unsuccessful. So if you look at the totality of evidence, what you learn is pseudonymization, pseudonymous data is easy to attack, which is expected. It's considered personal information. And de-identified data is much harder to attack, and motivated intruder attacks have demonstrated that empirically. So it's a little bit more nuanced than that. I know some folks who present on this issue tend to present one side of the evidence, but there are really two sides to it. You also have to acknowledge that some data is difficult to de-identify. So genomic data is difficult to de-identify. So you have to be specific about re-identification risk when you have to mention or talk about the type of data. So clinical, administrative data, survey data, all that is relatively straightforward to work with. Genomic, graph data is much harder to, social graph data is much harder to de-identify. And then the last point I want to make is there's mention of big data and more data available that can facilitate re-identification attacks. That's true, but technology to improve the identification is also improving. So there are two sides to the ledger here. There's the risk side, but there's the privacy-enhancing technology side as well, which is continuously improving to manage the risks from those attacks and to allow us to de-identify this data in a reasonable way. By no means it's perfect. The risk will not be zero, but in practice this has worked pretty well. And as I mentioned, these types of attacks have generally not been very successful. Thank you.
I agree with you. I just mentioned the way the EU policymaker does with these two kinds, two types, two ways of consideration this question. There is a way when we consider it, whether or not it's personal data, it's anonymous, it's not no more personal data, and pseudonymization is still personal data, and it's only used as a way to protect the data as encryption. That's it. I don't want to say, I'm sorry if I was not clear on this point, because I agree. I don't want to say one is better than the other. It's just different tools, and the policymaker decide not to deal with anonymization, because we also have a lot of studies which show the risk with depending on the tools. But I think the policymaker doesn't want to say this tool is a good tool and this one is not a good tool, because there is always there is always a risk in the future, and I think that the EU legislator doesn't want to labelize any kind of tools. It's too risky. That's my opinion.
Yeah,
that's it.
Yeah, I would say that I fully agree with you. You actually, in my opinion, touch upon like the main issue, which is not that the technology exists or doesn't exist. It's like its adoption. That we have amazing tool on both sides, but like most researchers, they don't know they exist, or they don't know how to use it, or they don't really care. Like when I see like even our own university, which is like the leading one on privacy and stuff, when I see a Ruby application, I'm like, no, it's not just because you remove the first name and the last name that this is anonymous information, because I have everything else from that person, and I could just go to your classroom and know exactly which student is it. Mm-hmm. So it's more like, like digital literacy, privacy literacy, and like adoption of the amazing tool, or like privacy in enabling technology that are being developed right now in the healthcare system. So I fully agree with you.
Yeah, and just a quick comment. Yeah, and thank you for that. I think that was a really helpful intervention. the only thing I would add to that is it's not just, I think it's not just de-identification, but also the governance frameworks that are important as well. And we're starting to see more of those and discussion of more of those in a variety of different contexts, the setting up, not just in the healthcare sector, but in the private sector and other contexts, frameworks for governing data sets that are going to be used in AI or data sets that may be de-identified. And I think this is a really important piece because it's there. It's not just the de-identified data, although there'll be standards and the organization will be very much involved in it, but it's also the framework that's put around the sharing of that data set, the contractual obligations, the commitment to not attempt to de-identify, and those can be very important. I just want to flag also some work done by Lisa Austin and David Lee at University of Toronto, where they talk about safe sharing sites, which is another form of data governance where there's a need for use of data that's not de-identified, where the identification is an important element of the research that's being done, and sort of the creation of these frameworks. StatsCan does this to some extent as well, where you can basically allow this safe sharing site to run the analytics and give you the results you need without compromising the anonymity of the data. So there are, like, data governance is a really interesting issue in this context.
Michael Wolfson, loosely connected with the University of Ottawa. You mentioned Teresa, formerly with Statistics Canada. I wanted to pick up on your comment here at the beginning, where you said that the current legislation, regulation was useless or wide open with respect to protection of personal privacy. When I wear my hat as a health researcher, I would state the opposite. It is a first-class pain in the butt to get access to data. If anything, I would characterize the current situation as dominated by a privacy chill. And if I can link that back to Nathan Cortez's, one of his slides near the beginning, talking about the FDA moving from pre-market to post-market, we already have the example of post-market surveillance of pharmaceuticals, which, the Vioxx example, I think, illustrates has been an abysmal failure, continues to be. There's the CIHR-funded CNODES activity, but it's sort of just dipping one's toe in the water to try and do things properly. And at the risk of disturbing my colleague here, Khaled, let me say that I really wonder whether it's feasible to do even Khaled's kind of anonymization of the relevant data sets if you want to not just evaluate drugs, but new AI applications where you would have sufficient information to be able to do a proper job. Then finally, let me reinforce your comment about the governance thing. The Council of Canadian Academies released a report in 2015 on timely access to health information, and one of the key ideas there was to say we really do need to do a better job at creating safe havens, or whatever you want to call them, or places where there are people who've gone through proper vetting to be bona fide researchers, and there's a set of more stringent rules, but that's the way that we're really going to be able to make progress in being able to make good and proper use of all this information. I can't resist adding one more thing. I think there have been some opinion surveys that point out that people first are already assuming that all this information is being linked anyways, even though it isn't. And they're disappointed when they hear that it could be used to save lives, but it isn't, because there's such a bottleneck, I won't say constipation, amongst the privacy commissioners of the country and data custodians.
Okay. No, and thank you for that intervention. But I do think that in terms of my critique of the system and the inadequacy of the system, your critique, you're saying it's too adequate, but which is also a critique of the system. And I think we do have a system which is, first of all, not adapted to the big data, artificial intelligence era, both in terms of protection of individuals and in terms of access to data. And we have one that is siloed and overly complex because of the way in which it's structured. So, I stand by my critique of the system, and I think on the other side is that we've thought of personal health information as being governed provincially under these provincial statutes, when more and more information is being collected through the private sector under a different regime, which is, by comparison, completely wide open and full of holes. And I think that if you take that, the composite picture, I do think that that is inadequate and problematic protection for personal health information, and on the other side, perhaps for appropriate access to data that's needed. So I think there's work to be done overall, but the regimes are definitely very different, and and I think your critiques are important.
My name is Noir Kamel. I'm a law student here at the University of Ottawa, and I have a master's in philosophy. I'd like to thank the panelists, first of all. But I wanted to ask specifically about the selective data, the purpose selective data. So if we're going to look at specifically healthcare as well, and we're going to choose data specifically relating to the purpose that we want, isn't that already implementing human biases and human conclusions even? Like, it won't give us any qualitatively different data because they're the patterns that we're seeking out, as opposed to allowing the AI to find patterns that we can't see. But then that opens the floodgates to everything, especially in healthcare. I don't know what doesn't affect my health. I'd believe anything. So I'm not a health expert, but I mean, I can see politics affecting health. Would that be part of the purpose? So.
The purpose could be broad. So it doesn't mean if you have a purpose, you automatically will have a bias. You could have bias, but you could have bias anyway. So no, I don't think there is automatically a link between the two problems. Yeah. So yeah, I hope it's help. Yeah. No. Yeah. Okay.
In the health system specifically, it might cover everything. So in that sense, would it be useful to talk about purpose specific?
Yeah, the purpose could be broad, but specifically precise. So you can say I want to cover everything because that's what you would like to say. It's not possible to say that for sure. So it could be a problem. That's why I say it's an obstacle if you don't know yet what you would like to find. Yeah, for sure.
Yeah, and I would just say that it's, it really depends on what you're talking about. I mean, if you're talking about developing AI to identify skin cancer in moles, your data is going to be images of moles, and it's going to be very focused, and you'll probably get pretty good results. But if you want to use Facebook posts to identify people likely to commit suicide, as Facebook was doing, then you've got a very specific and limited set of data and some kind of assumptions built into that, and I think you've got all kinds of room for troubling things to happen. And if you're going to use, which is what happened, or if you're going to use, Google search data to predict outbreaks of flu, or all these sorts of things, and so this is part of the problem. It does depend on the context, and it depends on who's doing it, and it depends on what the parameters are. But yeah, there's going to be probably some really useful AI and some really scary AI.
Florian, we really need to finish up, but just one last.
Yeah, it was. A quick last question.
Thank you. Nicholas Terry, Indiana University. I wanted to refer back to the first panel and Brother Frumkin's continual crusade against health exceptionalism. And I wonder whether the GDPR is an interesting example of how you can sort of have your regulatory cake and eat it, in that here you have a domain agnostic system, yet within it you recognize, as the directive did before, you recognize special classes of data, such as health data and now some genetic and so on. And I wonder if you could reflect on how you can have a general regulatory, agnostic regulatory system, yet coexisting with sensitivity to special forms of data. I think that might be a really interesting model.
Okay. I have nothing to say. Thank you, Florian. I don't know. I have to think about it because it's two different regulation and different kind of approach. I should say so. Maybe Teresa will have an idea.
The one thing I'd add there is context is really important. And so in Canada, we have a publicly funded healthcare system. Which we're struggling, I think, in a lot of ways to maintain. And so, there are different ways that you can conceive of health information that's collected via that system within the context of that system in terms of the public interest in its reuse in certain contexts and for certain purposes and in certain ways. And there's interesting questions about who should benefit economically from the data that comes from the Canadian public health care system. And there's a lot of interesting questions in there, but I do think the fact that it is a publicly funded healthcare system should factor into how we think about the reuse of the data on a whole range of different levels and on a range of different issues than if it were a private sector context. And so, I think there are ways in which health data is exceptional and is different, but it does depend on context, and I think we have a particular context here.
Perfect. So, Thank you to both our panelists again, and everyone for the conversation.